the idea of asking for a stay of execution of a ruling of the Speaker, there is really no legal basis for a stay of execution of a ruling of the Speaker. The court, the Supreme Court and other courts, have the authority to stay execution of decisions within the court system.
Okay.
But you don't apply for a stay of execution of something that happens within another arm of government, which is the arm of the Speaker. Now, the impression was given that because this is a matter for interpretation and so on, therefore you can run to the court. But again, there are clear decisions of the courts themselves, including the Supreme Court, decisions which make it absolutely clear that you don't, under the guise of interpretation, take to the Supreme Court things that are within the preserve of other courts or other authorities in the system. Very clear decisions. And I think we have to have a little law class here because, because I like some of these passages from the decisions of the Supreme Court itself, to be laid out for all of us to look at, because all of us have a responsibility to protect what is in the Constitution. The Supreme Court is not a law unto itself, fortunately. Neither is the Speaker a law unto himself. We all have responsibilities. So when, for instance...
Would you then say that the Supreme Court erred in that?
Well, definitely, in many respects. In fact, as I will try to perhaps explain if there is time, it erred in multiple respects. As I said, in the first respect, just running and saying there's a matter of interpretation, therefore Supreme Court, I'm before you, is not acceptable. The courts have said in many cases, there's this case, for instance, Eduamua and Chum, where it was stated, Aqua, the Justice of the Supreme Court, as he then was, makes the point that all courts, tribunals, institutions, and all individuals are bound by the provisions of the Constitution in the adjudication of disputes before them. In summary, then, whereas the original jurisdiction to interpret and enforce the provisions of this Constitution is vested solely in the Supreme Court, every court and tribunal is duty-bound or vested with jurisdiction to apply the provisions of the Constitution in the adjudication of disputes before it. And this jurisdiction is not taken away merely by a party's reference to or reliance on a provision of the Constitution. So just running to court and saying, Supreme Court, I want you to interpret such and such for me, does not mean that the Supreme Court should go ahead and do that. The Supreme Court has to decide whether it has jurisdiction. And I'll give you another example of something that
But I thought that interpretation of the Constitution is the exclusive jurisdiction of the Supreme Court.
Yes, but the court itself has made it clear that that does not take away the responsibility of others to apply the Constitution. Every institution, every court in the land applies the Constitution. In applying it, they have to understand it. They have to interpret it in that sense. So the courts have made it quite clear that when you talk about the exclusive jurisdiction to interpret, it is not everything about some provision of the Constitution that leads to the requirement of interpretation.